Why did you decide to get involved in the Target case?
It was not by choice, but more as a result of circumstances that it occurred. And what I learned about Target from the court filing were two major issues that intrigued me. Number one, Target's mismanagement of its operation in Canada, and number two, the law that it chose to use to protect itself. That law, called the Companies Creditors Arrangement Act, is a sort of an old Canadian law that has been revamped and is used specifically for companies that wish to remain in business and simply restructure. And what was odd about the use of that law is that Target had no intention of restructuring. What they had the intention of doing was simply liquidating all their assets, getting as much money as they can from the sale of their assets, and getting out of Canada.
In what ways do you feel Target acted in bad faith?
There is a feeling and a sentiment that many lawyers had at the beginning of this case that Target knew well in advance, Target Corporation in the United States knew well in advance that they were going to exit Canada and seek protection from the courts. We being the legal community and my firm, were convinced that Target had planned this exit well in advance, and we were able to convince the court to provide to us an investigative mandate, which is very unique and probably the first time this has ever happened in an insolvency process, where the judge gave us a complete and open mandate to investigate Target's planning of its own insolvency. We were able to ask questions about when they started the planning. We were able to ask questions about what they did, and we determined that Target, as early as September 2014, actually met with their advisors to start planning. Target had their own executives in the United States sign non-disclosure agreements so that they could not tell other Target employees, particularly Canadians, that they were going to go bankrupt. So that the Canadian employees never knew in October, November, December, and January that there was going to be an insolvency in January the 15th. So they kept ordering, they kept going to their suppliers and saying, send me more product, whereas the executive in Minnesota knew, or probably knew, that they never intended to pay for it. So that's the bad faith that I think is most significant. There's been other issues as well. Target's failure to make complete and honest disclosure of certain documents, of certain intentions, such as foisting a $2 billion debt on the suppliers from out of left field after they got protection, and not disclosing timely documents. So I think that gives you the flavor.
Lou, what are some of the key facts that most people might not know about that is happening with the insolvency?
If this is a restructuring statute, why is Target Canada being given that opportunity to restructure when in fact it's not? It's purely liquidating and leaving Canada. And so it's an odd scenario. A lot of people also don't know that Target Corporation, in fact, decided to get involved in this insolvency by seeking protection for themselves. And that's a very unique and odd scenario. Target Corporation is one of the top 40 largest companies in the world, yet it obtained a protection order from a Canadian court to protect it from its guarantees that it gave on all the leases. So Target US guaranteed many of those leases across Canadian shopping centers. And that's why the landlords often gave Target Canada a big space, because their parent was protecting them. Under the order, Target Corporation is also protected, and that's never heard of. So I think those are all the unique situations that not many people know about. Target Corp's come in here, they created the insolvency, they're not insolvent, yet they're still receiving insolvency protection. We should care about our law, and we should care about how people use our law, and we should care about the fact that an American company has come in and taken advantage of a legal process that was never intended to be what they wanted it to be. We should care because there are 18,000 people unemployed, and we should care because there's hundreds of millions of dollars of suppliers, Canadian, that may not get paid. And in the future, we need to be able to make sure this doesn't happen again, and we have to make sure that that our government changes the law, that our courts are aware that this law can be taken advantage of. And I hope that what we have done at Target for our group may assist in keeping Canadian suppliers, Canadians, and other stakeholders a little better protected, so that the next time it happens, courts will know that we've created a precedent and that this will be there for the future.